Mesdames et messieurs, my dear friends, I'm very sorry not to be with you today, and it is from my office at Louisiana State University, Baton Rouge, Louisiana, that I'm recording this presentation, as I have done on a couple of occasions in the past. I cannot tell you how much I miss the friendly Viennese atmosphere, the hospitality we always have on these ECTIL conferences. But I had to stay there in Louisiana to make sure someone takes care of the future of the civil law in that part of the United States in those days of severe financial crisis. And that takes me to French law and the development of tort law in France, my home country. I tend to discuss legislation when I do it from my office and cases when I am in Vienna. And we happen to have an important piece of legislation with a law of June the 17th, 2008, that reformed the entire title on prescription in the French Civil Code. This text, this new law, is not entirely based on the Catalan project of reform of the law of obligation that I have commented on in the past. This is not necessarily bad news. The new law actually comes closer to some accepted European solution and may simplify to some extent this complicated area of the law. How does the law define prescription? There is a little bit of confusion here. The French tend to privilege aesthetics over substance. The reform is addressing extinctive and acquisitive prescription. And we are there again with the formal garden, l'art du jardin à la française. We have to distinguish extinctive prescription, defined as a technique extinguishing a right based on inaction during a certain time, from acquisitive prescription, which allows you to acquire rights. Extinguishing a right, are we talking about substance? Are we talking about procedure? Reinhard Zimmermann, commenting on the Catalan project, which had the same language and the same overall approach of the two types of prescriptions, indicates nonetheless, insists on the fact that in French law, extinctive prescription is a defense and deals with procedure more than with substance. Indeed, Article 2247 says that the judge may not raise prescription on his own motion. It's only the parties that may do that. And also, prescription does not extinguish the obligation. According to French law, there is no restitution possible in the case of the payment of a prescribed debt. Indeed, the payment is justified by a natural obligation. This is based on Article 1235 of the Civil Code. Let us go now to prescription periods. The purpose of the reform was to ensure some convergence with European law or European laws and simplification. Article 2262 is abrogated. French law had this antiquated general prescription period of 30 years, a very long time, that served as a default rule. Now, the default rule is 5 years, that's 2224, for personal actions. And we keep a special rule of 30 years for real actions based on ownership of immovables. The 5-year rule applies to all actions that had a special rule in the past, often with shorter periods of time. So there is some simplification here, and we will have fewer special rules from now on. So there is obviously a simplification process here. However, some exceptions exist, sometimes with shorter and sometimes with longer periods. For instance, we have a 30-year prescription in the case of damage to the environment. This is taken care of by the Environmental Code. We have a 20-year period when the damage is caused by torture or acts of barbarism or sexual violence on minors. And we also have a 10-year period for the actions in compensation of bodily injury. So let us focus now on the action in damages in the context of tort, but also contract disputes. Indeed, the new law makes no distinction between tort and contract. At least in this area of the law now, contractual and extractual liability are unified. This is good news, and that may be a step towards European harmonization, the French not drawing the line between contract and tort, as many other countries are doing. So the basic distinction that we have here is between bodily injury and other heads of damages. For bodily injury, we have a long 10-year period running from the time of consolidation of the initial or aggravated damage. And as I said, a special 20-year period when we have acts of barbarism or sexual violence to children. For other heads of damage, the default rule of 5 years applies. And there, time is running from the time when the person knew or ought to have known the facts giving rise to the claim. This subjective system, based on knowledge of the facts, has been improved. The Català project requested actual knowledge of the facts. The addition of the words "or ought to have known" is leading French law towards other European system. So we end up having a solution that is similar to the one in German law and also similar to the unidroit principles, and we are getting closer to the solution at Article 14.301 of the Principles of European Contract Law with the test of reasonable discoverability. So all this is completed with an objective long stop period of 20 years that start from the facts giving rise to the right. But the long stop rule of 20 years does not apply to bodily injury, where the 10-year period is starting from consolidation of the damage and not from knowledge of the facts. There is an issue that remains open with the reform, at least one I'm going to focus on in this short presentation. The new law, it's not clear whether the new law permits clauses limiting the prescription in the case of bodily damage, 10-year period. It's a long period of time, and it may be tempting, given this long period, to try to make it shorter by way of contractual stipulation. Article 2226 is written in such a way that it is not clear whether the rule is a mandatory rule, règle d'ordre public, or not, and the courts will have to decide on the issue. And there is a tension here, you know, the period being long, the temptation of making it shorter will clearly be there. Well, to conclude this remark, I hope to be with you in the years to come to discuss the first cases that will be decided under the new law, and of course all the exciting cases that are going to appear in my written report. I wish you a very successful conference. Have a good time here in Vienna, and I see you next year. Goodbye. Au revoir.